Abzine of Downing Fry and NABOR, president of NABOR 2023. And we've got Mike Hughes and Jerry Murphy, both brokers at Downing Fry as well. And then we have, there's Vicky. Oh, hello, Vicky. We have, what's really neat about this class is that we've got agents on here from all across different brokerages throughout Southwest Florida. A lot of you are signing in from, areas outside of the country even. So I really love the kind of the diversity that we have here. So let's lean on that. And if people have questions and they want to input some stuff, feel free to jump on, insert yourself into the discussion, or even put something into the chat feature. But today, what I'm hoping to talk about is FIRPTA. Now, Mike, we talked about FIRPTA this morning. I gave you a heads up that this is what the topic was going to be about. And you said what?
23 years ago, I knew nothing about FIRPTA. I now know how to spell it. So when I get a FIRPTA question, I turn it over to Christian or Don and greatly appreciate their help.
Yeah, and I think actually it's something that Nick and I did in our class last week. I said, all right, I can give you the rules, I can tell you the forms, but how do you sell this? How do you operate this way when you're the real estate agent? And Mike, you said, I just refer it to you guys. And that goes to what I see as that's issue spotting. And it's an incredibly important part of this job. And I do it myself is I don't pretend to know the answers, but I do know the issues. And FIRPTA is one of those things like, yeah, that's something that comes up. It's when a seller is not a US citizen or a US resident, they're subject to a withholding tax at closing. And that's where it ends, right? I don't know how to calculate it. I don't know, what I'm supposed to do about it. I call the attorney. Let me call Christian. Let me call Don. Let me call my broker. Let's figure out how to deal with this. So one thing that's come up several times is, well, how does this affect my buyer? And this came to the forefront recently. The buyer was a foreigner and the seller was a foreigner. And so the question of how does this impact my buyer actually had an additional layer this time. So generally, it doesn't affect your buyer very much. This is not something that we have to worry about very often. But it's the question that always comes up. The buyer says, hey, what about FIRPTA? I'm a buyer, I'm from out of the country. What do I need to worry about? And I think step one, and this is where I want to lean on the other realtors in the room. Step one is, what do you tell your buyer to convince them to sign the contract? How do you alleviate their fears if it's a Saturday or Sunday, you haven't had a chance, or I haven't responded to you just yet? How do you tell your buyer, let's sign and move forward? And I think, Dad, are you on here?
I'm here. Can you hear me all right?
Yeah, I can hear you perfectly. So tell me, what's your kind of opinion on how you educate a buyer, what you would tell them?
Well, you don't necessarily want to educate the buyer. You want to make sure the contracts are signable. That way you can point to paragraph 7 in the FARBAR contract or standard A in the NABOR contract and say, look, you can assign this to whatever entity your tax advisor recommends. We know it's an issue with you, whether you're from Canada or France or wherever you might be. But these contracts are assignable. You're totally safe in signing it now in your individual name, and then call whoever your expert is. And depending upon their net worth and what country they're from, because we have different tax treaties with each country, you can decide how you're going to hold it at closing or on the warranty deed.
Yeah, and that's the big bat on that information is that contract is 100% assignable. So in my opinion, the key would be getting it under contract and then handling who's going to take title later when you're the buyer. So if Nick is our selling agent and I ask Nick, what do I do? I'm a foreigner. What do I need to worry about? And you say, well, let's talk to the attorney. Let's talk to the CPA. But in the meantime, I don't want you to miss out on the purchase. I don't want let's not waste any time going under contract because you can always assign it later. Nick, have you ever had to use that, had those discussions before? Sorry, I muted you. Sorry, Nick.
Not so much with FERPTA, but I've dealt with it a lot with like trusts and where they want to put into the trust or different things like that title wise.
Yeah, so actually that's really good. So this is a very flexible thing. You can use this anyway. I would say when you have a buyer who's non-committal about how they're going to take title, that they might have a trust, they might put it into an LLC. Should I put my wife on it or not? The good answer to say is, well, it's 100% assignable. The buyer has the unilateral right to assign it prior to closing. I think the contract technically says 15 days, but in practice, Dad, have you ever seen a seller kind of fight us on an assignment? The day of
No, I've
closing?
never ever had that come up. Usually you get an email from your client saying, add my wife, or I'm taking title in this LLC. And you just need to give the selling law firm enough notice so you can prepare their warranty deed correctly. I mean, if the seller is in Timbuktu somewhere, you can't tell, the other law firm, hey, 5 minutes before closing, we need to have the deed, read this. So you got to
They
be
can say
someone.
no. They can say, you're driving me crazy. No.
And we all do it to each other. We honest to goodness do. I mean, we'll let them, how are you taking title? We do it day in and day out. And we always take into consideration where the heck the seller is and how hard is it going to be. I mean, I had one this morning where one of the sellers is in jail. So, you got to factor that into how much notice you give to the other side.
So the next part on this is, and I'm going to see if I can highlight this for everybody. The big question we get is, all right, well, what do I have to do special about the contract? Because again, you're in that mode of you don't want to have your buyer sign everything if you don't know how to fill out the contract because of FERPTA or some other reason. A lot of times we also get that same question for a 1031 exchange. What do I need to add for the contract? And what I'm going to point out to you, and I believe I'm highlighting it here, this is the standard NABOR contract. This is the new version that came out just a couple of months ago. And if you look at Standard M, Foreign Investment in Real Property Tax Act, or FERPTA, as Mike knows how to spell now, the language is already in there. So let's read the definition, because I think the definition of this is really good. The seller who is a U.S. citizen or resident alien who furnishes buyer with an affidavit attesting to same is exempt from FERPTA. So if you're a U.S. resident or a U.S. citizen, FERPTA doesn't apply. So you can ignore it if you live here. If seller is a foreign person or entity, buyer shall deduct and withhold from the purchase price or collect from seller if the net proceeds are insufficient, 15% of the purchase price. That's the amount. We're taking directly from the statute, the Internal Revenue Code. So 15% of the gross purchase price, and remit the same to the Internal Revenue Service, the IRS, within 10 days after closing date. Dad, why do they make this the buyer's responsibility?
Buyer has control of the money. The buyer will still be here after the deal is done. The seller, I always flip it around when I'm talking to, say, someone from Canada. If I were selling something in Canada and they gave me a check, I'd come back to Florida, put it in the bank, and I would not be calling the Department of Revenue in Canada asking if I owed money. It's harder to reach me as the seller when I'm in a foreign country, bottom line. So they put the burden on the buyer because the buyer is still here and the real estate's still here. So it's just an easier way for collecting it when they passed this in 1980.
Yeah, it's just the way they wrote it. And they're trying to hold someone responsible. The buyer's going to be here, the buyer's going to own the property. Do they lien the property if this wasn't done
Oh,
correctly?
yeah, gosh, yes, I've had that happen. And there are exemptions from it. If you have it postmarked one day late, they lien the property. That's happened to me. But fortunately, I was able to find an exemption. The criminal and civil responsibility is wholly on the buyer. We have that NABOR addendum where the buyer certifies, what percentage of time the property's in use he intends to use it. That's something I guess you might want to touch on. I don't know whether you want to do that now or later. It's up to you, Chris. But bottom line is the property's here, the buyer's here. We can get them. So they put the pressure on them.
The interesting part is when I was practicing in Atlanta, FERPTA came up, I don't know, maybe twice. Yeah, twice. It was like nothing. It might have only been once. Because you don't have such an international population, at least in the market that I was serving. But here in Southwest Florida, it's almost like every other buyer, it seems. Dad, I think you sent me an article recently that said that this is on the rise. Is that right?
It's Sunday's Naples Daily News, page A8 talks about the numbers. They went down 39.9% nationwide. And now they're coming back, and a disproportionate amount of them are coming to Southwest Florida. So they're going to be hitting us. And it was just recently I had a realtor ask, hey, Don, you've written a lot of articles on the seller side, but what about the buyer? How do we deal with a foreign buyer to get them to sign a contract? And I said, well, that's a good question. We actually never wrote about that.
And then we're going to hit on that. This is the part that I think is wild. Meanwhile, an estimated 1 million Canadians came to Florida in the fourth quarter, bringing the 2022 total to 2.8 million. By comparison, 4 million Canadians flocked to Florida in 2019. That's still a huge percentage of their population, and we don't have that many transactions in Southwest Florida. That's a lot of people that we're having to deal with. And it's funny because we don't usually consider, I mean, maybe a lot of people think differently than me, but Canadians are my friendly neighbor to the north, right? They've got the same phone numbers as me for the most part. Like I don't usually have any, unless they remind me, I don't even think about it. It just sounds like it's northern Michigan. This is very relevant.
Christian, even going back, I mean, this law was passed in 1980, and for people who are new, young agents, I mean, back then, I mean, we had an article on Walter Sauerman, if you remember that one. That man was from the Canary Islands. I mean, I was dealing with him in 1981. We were dealing with people from Belgium down here. I mean, your grandfather, Belgian clients, Dutch clients, Welsh clients, German clients, and God help us, Russian clients. They were tough to deal with. That was ordinary. People on the island who are from Venezuela. I won't mention them by name, but Don's your older brother's best friend, Manuel. These were commonplace, and they're going to be commonplace again. It was only because of what was going on that they haven't been here.
Yeah, and we did see where last year a lot of foreigners sold. But that it's kind of like a wave, it's an ebb and a flow. So it's likely to pick back up. If we go back to what we were wanting to answer before, which is what do we tell a selling agent about FIRPTA? The big thing again is I don't want this to hold you up. I want you to make an offer, whether your buyer is a foreigner or not. The contract already accounts for this. It's really the seller that matters the most, with one little distinction that I will share with you about in just a second. But we're going to look at the standard language in these contracts. We look at the seller instruments and expenses. It references FIRPTA. So it says number 3, these are the seller costs to broker compensation, an affidavit regarding liens, possession, and withholding under FIRPTA in a form sufficient to allow gap coverage. And then if you look at lines 380, if seller is subject to withholding under FIRPTA, charges associated with it. Again, these are making the seller costs. So you don't, as a buyer, you don't have to add anything in. That's the kind of point I'm trying to make. We already looked at standard M, which does a good job of defining how FIRPTA works. And then you go to this part, addendum. And maybe this is what gives people pause. FIRPTA buyer residential use certificate. Mike, have you ever seen that form before?
If I have, I don't remember.
Yeah, I think that's fair. So let's see if I can show you that form. So, because again, this goes to the point, I don't want this to slow you up at all. Let's see if I can download it.
You also want to touch on whether you should even use it.
Well, I think that's the important part. So again, we're in that mindset. It's Saturday night. You're trying to put an offer together. You see FIRPTA as one of the potential attachments. You find it in your documents online, and you say, well, am I supposed to use this or not? Dad, you want to give me a quick summary on how this addendum works and
Yeah,
whether you should use it?
it comes right out of the statute. It's 1445, the Internal Revenue Code, and it's fleshed out much more in detail in the regulations. What I tell selling agents is, don't volunteer the form. If the seller demands it as a condition of having the offer accepted, then we can talk about what this thing means, but don't volunteer it, because you might be able to use it later on to induce the seller to repair something you want repaired. If the seller's being a little hesitant of, fixing some minor thing, you can offer this as a way of compensating him for doing the repairs.
Why is this a value add for a seller? What's the point of this?
They get their money back faster. If 15% is being withheld, let's say it's $2 million. You're looking at $3 million. Is it 3 million? 15% of 2 million is, I believe, 3 million.
Well, you're at 300 grand would be
300 grand. I'm sorry, 300 grand. They get their money much faster. Well, you can't use it for this. If it's under $1 million,
let's say say it's under $1 million. This form allows the seller to withhold less than the 15%.
Yeah, let's say it's a million even, and they're asking the buyer to sign it. Instead of 15% of $1 million being withheld,
150,000.
it's 10%. So they get $50,000 faster. They get it in their hands.
They get it at closing, right?
At closing. And if you're, depending upon what time of the year you're in, if you're at the beginning part of the year, like we are now, the only way they're going to get that money and perhaps some of the rest of the money back is to apply for withholding certificate, which the IRS has 90 days to respond to. I've seen them say we need more time. I've seen during COVID them not respond to it at all. So it could be something they have to wait 1.5 years before they get the 150 back.
Yeah. We had it's this whole calculation of how you apply FERPTA, and it's a little bit in the weeds, but it has changed drastically on what people lean towards because the IRS is so backed up. So because the IRS is so backed up, we want to limit how much is withheld at closing as much as possible. So if you have $1 million deal and they don't sign this form, the seller's going to have to remit 15%, 150,000 at closing. If the buyer signs this form, they only have to remit 100,000. And if the property is under 300,000, they don't have to remit anything if they have this form. And it's wild. That's great. So in your scenario, the $2 million deal, should a buyer sign this? Should a seller require?
It wouldn't be relevant because it's over $1 million.
It's not relevant. So it's only is this number 3. If it's under 300 or between 300 and $1 million, that would be the only time this even matters.
Yeah, this is
Not
actually
required.
Interesting. People ask, why is there an exemption for 300,000 or less? That makes no logical sense. Why you would exclude a whole group like that? And the answer is actually, when you look at when this law was passed, 1980, 42 years ago, the average transaction in the United States was 300,000 or less. And a big lobbyist to Congress was the National Association of Realtors. And they lobbied Congress to
Nick, we
give
talked
them
about them last week.
Yeah, well, it's like, hey, look, you're messing with our deals. And so they gave them this exemption because, NAR donates a lot of money to individual Congress people running for office. So there is no logic. It was money.
It was a lobbying effort. They were trying to limit the pain for the majority of people. So
Right.
Just as a summary on that form, if the property is over $1 million, it's not relevant. It should not be a part of your offer. It should not be something that as a listing agent, you request the buyer to sign because it doesn't help or hurt anybody. It's just kind of irrelevant, doesn't matter. If you got it signed, fine, that's okay. But if it's under $1 million, now all of a sudden it becomes relevant. It's a thing. But going back to my key, your Saturday night, you're trying to put an offer together.
Yeah.
Does this need to be included?
If the seller insists, hey, the only way we're going to accept your offer is if you sign this, then you have to look at it and see if your buyer even qualifies, whether he'd be lying if he signed this, because if he's lying, then he's really in deep trouble with the IRS. So they have to understand it. And that's where I tell the agents, I mean, essentially this thing means is it's the buyer's intention for the first 2 12-month periods to use it at least half the time it's being used. Now, if it's only being used a month a year, or a month every 12 months, that means, 2 weeks in a day.
Yeah, let me reread that. Plans to reside at the property at least 50% of the number of days the property is used by any person during each of the first 2 12-month periods. Nick, do you know what that means?
Being used, that's all. And you get rich people down here who have 6 homes. I mean, your neighbor, for crying out loud. I mean, how often is he in his house?
Well, I think the key, another way to define this is, do you intend on renting it? Mike, you have your hand raised. Did you do that on purpose?
Yeah, I was just kind of testing this thing here. Question, have you ever had a seller try to hide their foreign status?
Maybe.
Good one.
Maybe. It is a good one. It's a very good one because we asked the seller to sign an affidavit as well. An affidavit that they are not a non-foreign individual or entity. And could they lie? Yes.
Yeah.
They've probably done it and we don't know. It's possible. But I would say that doesn't happen often. From what I can tell, when you're a foreigner, you're a foreigner. And you just ask the question, hey, I'm a foreigner. What do I do about this? I live in Sweden,
Here's
right?
the dangerous thing, though, and this is in the regulations. If a seller is going to lie, and if the realtor knows the seller is lying, the regulations and the statute holds the realtor or the title company or the attorney liable up to the extent of their fee, and potentially criminally if they let this lie slide by, if they participate in the lie as an accomplice.
So when you're thinking about $150,000 liability, obviously that's a lot of money. No one wants that. But we're doing a deal right now. It's 5.6 million. It's over 800,000 in withholding. And if the seller were to lie to us on that, and there's a lot of liability, that puts everyone in a problem.
You'd be dealing with special agents of the IRS. I mean, they'd come after realtors and lawyers and whoever had knowledge of this.
So Andrea brings up a point. She says, if the property is under 300,000, but not for the buyer's personal use, then the 15% applies. Yes, that was correct. Yeah, Nick.
But you can have a change in circumstances. People get very upset by this, and they feel like they're promising the IRS that it's going to be used this way for the next 2 12-month periods. And that's not the case. It's your intention at closing. If you have a change in circumstances after closing, the stock market goes south, you get fired, whatever it is, and you got to rent it out full time. Well, you just document that, you just had a stroke or whatever it is, and you have to rent it out full time, and you're fine. You're absolutely okay.
So on that point, it's intent. Nick, did you have something you wanted to pinpoint?
Yeah, I was just going to say, like, when I have a listing that where FERPA applies, I actually have the seller sign that addendum with the listing contracts, just like a seller's disclosure. And I actually upload that on MLS and have, put in there, sign the seller's disclosure. If there's an HOA disclosure, same thing. And also sign that FERPA addendum. I have that
I
included.
love it. So yeah,
with
you're giving the buyer a roadmap. And so on Saturday night, when the buyer's
Correct.
agent is trying to put an offer together, they see that you've uploaded this on MLS. They see your seller disclosure, your HOA disclosure, condo docs, whatever. And you're giving them the roadmap. You're telling them, I want this signed when you make your offer.
Correct.
I love that. And in that way, Nick, you're taking a buyer's leverage away from them on this one point. And my dad and I talk about this a lot. We've written articles about it, but let's say they don't do that. Nick, you don't have the buyers sign this before you go under contract. The buyer is not obligated to sign this afterwards. And so now your seller's like, look, Nick, you screwed me on this. You didn't have them sign before we signed. You didn't even know about this.
Right.
So that's a big deal. That's something that you're doing this, you're taking that risk off the table. You're not allowing the buyer to leverage it into it. Kent, I have a question for you there.
I am, sir. What's up?
So lying is a big point under this. Actually, I might come back to you in a second on this, but this is the point I wanted to make to you. You have something similar to that intent language. When you broker a loan for someone, you're asking them to swear an affidavit or at the closing statement on the closing papers, how they intend to reside in the property. Primary residence, secondary, or investment, right? Those are the three
Correct.
options. Has anyone ever lied to you? How does that
Of
work
course.
out?
It's the number one cause of mortgage fraud is residence fraud. Typically it's then there's specific rules as to when it can be a second home, when it has to be an investment property. There's mileage rules, like a 50-mile rule. There's occupancy rules. There's different rules for the different residency types. They're pretty standard. They're not gray. It's pretty black and white. But yeah, intent is what it is. I mean, somebody buys a property with an FHA loan intending to be their primary residence, and 6 months later, they change jobs, or whatever the case may be, they move somewhere or need to relocate, and they start renting it out. It is what it is. It's just, but yeah, intent versus a malicious attitude is definitely you just have to deal with it. But it really comes down to common sense.
So I draw a lot of parallels there between that intent language. And it kind of works the same way. If we see something, it's fraud. If we don't see it, then there's other things that might pop up later. But I think that's very relevant. It's funny, I'm a little flustered because my computer just fell.
Oh, if I could, Christian, I mean, this goes back, and most people don't know this. I mean, I did criminal tax fraud work initially. Can you still hear me, honey? Hello?
I can hear you, Don.
Okay. When you do criminal law, documenting people's intent is really important. Lying to the IRS, I mean, you look at, was it Martha Stewart, went to jail, they try to make an example out of her. Lying is a big deal. You do not want to deal with a special agent. There's no way a selling agent is going to know everything they need to know about this. So we always hit, make sure it's assignable and know enough about the broad outline of the statute so you sound professional. Okay, you know what it is. You withhold 15%. It can be knocked down to 10% if it's $1 million to 300,000. It could be zero if it's under 300,000. What does the buyer's situation have to be if they're going to sign this thing? And the ultimate responsibility on the buyer. And what happens if the buyer doesn't want to go get a taxpayer ID number? We had that yesterday. They can be fined $10,000 because they don't know how to match the money up that was sent in to that particular individual. So they get hit. They lien their property. You want to be knowledgeable enough so you can show your client that you've done this before, you've dealt with people from different countries before. It's not a new thing. That way they're comfortable in coming to you. If they ask you something that is technical, what I was always taught, and actually it was by my father, you respond by saying, that was a wonderful question, Kent. I don't know. Let me call my tax expert, and just call us. You don't have to know everything, but if you try to persuade people you know everything, they're going to see through you in a heartbeat.
Don, all they have to say is, I have Ross title on speed dial. Give me 1 minute.
And that leads to the perfect transition.
Thank you for the plug, Kent. But I mean, you all have a team. You have your inspector, you have your lender, you have Kent. You're going to have a tax person. Don't be an expert in everything. You just want this to be assignable. You want to know that it's there. And by the way, it's not just the sale of the property that there's withholding on. It's rents and things like that. And that's a different code section. And it's 30%. So you call me, call whoever you know who's a tax expert. I mean, I have a master's in this, and say this guy's part of my team, and you look great. Nobody expects you to know everything.
So I have some notes. I wanted to make sure we're hitting all of them. So FIRPTA, what is it? It applies specifically to foreign sellers. So if you have a foreign buyer, this doesn't necessarily apply to them when they buy. It applies to them when they sell. Number one here, for buyers. All right, so what does a buyer need to worry about? Well, if anything, they could maybe talk to us ahead of time. What do they need to know about it if they ever sell? Is there anything they need to do now or should do or think about in advance of selling? that, I think that is all really relevant. And to Mike's point earlier, it's issue spotting. You know, we know it's not a huge deal for buyers generally, but it will be something they'll want to know about for future reference. So that's how I would think of it if I'm a buyer. The buyer's agent, I know that the contract already protects us for this. The seller's obligated to do it. It's in the form, in the contract, we can reference it. There is an addendum, and unless Nick is making you sign the addendum, it's not necessary to include as part of your original offer. Andrea says, I think it's very important how foreign nationals are taking title. Absolutely, Andrea, I think that is perfect, but it may not need to be something you decide when you make your original offer. Because the contract is assignable, we could put it in one of the buyer's names and then assign it to someone else that won't be subject to FERPA. That is possible. We've had a couple of comments. Let me see if I keep going. So issue spotting is really great. Rely on the experts. You're not just relying on us at Ross Title and Ross Law, but we have CPAs that we really adore. Rosa Skoll is someone that we're very close with, and she handles 99% of our clients on their FERPA issues. There are companies I've worked with in the past, like FERPA Solutions, who are wonderful. In fact, a little plug for FERPA Solutions is they have a wonderful tool on their website for how you calculate FERPA. It's actually really, really well done. The addendum and strategies, we talked briefly on that. There is the addendum. That's not just a NABOR form. That's a statutory form. We have those forms for closing if the buyer is willing to sign it as well. Strategy matters. So, if you're the buyer's agent, hold off on getting that signed and maybe use that to get some repairs that the seller otherwise wouldn't give you. Because if you can save the seller $50,000 in withholding, maybe they'll give you a new water heater, and that just pushes them over the edge and says, okay, fine, we'll do it. And then the how-to and recent developments. This one's fun. This story's a little wild. And Dad, you touched on this briefly, but one of the little idiosyncrasies of the FERPA withholding is that not only does the seller need a taxpayer identification number, an international taxpayer, it's called an ITIN, which a lot of foreign sellers don't have. They're not going to have a social security number and not going to have a TIN. They have to apply for it, the seller. Separately, so does the buyer. And so we had a deal this past week where both the buyer and the seller were foreigners. They were both Canadian. And the buyer was shocked to learn that they were going to have to apply for an ITN right now as part of FERPA. And we talked to the accountant on this. We looked into the regs, we did some research, and the resounding result of all that was there's no option. The buyer has to apply for an ITIN. And if the buyer were to lie to us and not apply for it, there's a $10,000 penalty. Well, that was pretty wild.
Well, it's just, he was concerned about paying taxes in this country. He's not, just because you have a TIN number doesn't mean you're paying taxes. If the property's just sitting there, there's nothing to pay taxes on. It's only when you sell. And the whole point to this FERPA, because people think it's vindictive or we're punishing people from other countries, is just to make sure they pay the same tax when they sell that Christian Ross would under the same circumstances, or I would, or Kent would, or Nick would. Because once you're out of the country with the money, you're not going to pay. And
there's just no better way to do it.
There really isn't. It's not a punishment thing. And how to take title, I mean, it's nice to know different ways people do it, but typically when I work with somebody, I'm working with a Canadian lawyer, a Welsh lawyer, or a German lawyer, because I don't know the net worth of the buyer. I don't know the family situation. They have different rules on leaving money to your wife and all that stuff. The tax treaties are different. So I defer to them, and then I implement it, in hand with the German attorney or the French attorney or the UK attorney, because we're new to them. They haven't known us all their business lives like they've known their home country's attorney. So it's really a lot going on behind the scenes.
There is. So Vicky has a great point that she wants, it will help me clarify this hopefully. So she says, I'm curious why you would say not to bring it up. I always have the FERPA form when I do a listing of a foreign person. I certainly wouldn't not bring it up. I'm trying to think, if I'm a listing agent, I need to know about this form. I need to ask the seller if they're a foreign individual. And I absolutely, as a listing agent, would have this form, just the way Nick was suggesting, maybe have it on MLS, or just give those instructions to any potential selling agent. As a selling agent, you could bring it up. You could offer to sign this form as part of your Saturday night signed contract, your signed offer. You absolutely can do that. But what I'm saying is, if the listing agent's not aware of it right now, maybe hold it. You know, if Nick forgets to ask me to include that in my offer, I'll send him the offer, we'll agree to the purchase price, and then I'll kind of hold this over his head for the next week.
Well,
Right, Nick? I would do that, huh?
If I could, Christian, I
do.
tell buyers, what if, like under the NABOR contract, you have your inspection, you have a whole list of things to fix, and they're usually minor stuff. And this foreign seller is being, for want of a better word, not nice. He's not agreeing to fix a single thing. You know, then you bring up and say, look, if you do this nice thing for me, I'll do this nice thing for you that will help get you your money quicker. So it's just a chip. And if they've been nice all along, the buyer sometimes asks, should I sign this, Don? And I'll say, well, if they've treated you like a human being, sure. You want to be a human being in return, of course.
Yeah.
But if they've tortured you for the whole transaction, kicked you every step of the way, that's between you and your God. I mean, I'd have a hard time with it personally, but it's a personal choice.
Well, and Vicky makes another distinction. She says FARBAR has to be checked to be assignable, and that's true. FARBAR gives you
Paragraph
options.
7. That's a middle.
Assignable, not assignable, assignable with liability or without it. So
Just make it
absolutely.
assignable and be able to know what FERPA is. It was passed in 1980. It's 15% for real estate. It's 30% for other stuff. It's actually like 5 different code sections altogether. But you have a tax person on your team because you just want to sound knowledgeable that you've done this a few times before, so they're comfortable with you.
So let's bring this full circle. Jerry, you've been patiently waiting, listening. And you are someone that I really love the way you kind of teach people how to do your listing appointments, how to make offers. You have very simple, straightforward advice. How do you, what has been, I haven't had a chance to ask you this, but what's your overall take on FERPA? Is this something that stops you in your tracks every time it comes up? Or do you just have kind of a go-to process, or what were you thinking of during this class?
Well, if I'm asked a question about it, I don't get asked it a lot. I have to go and check what it means.
Yeah.
And I think that's good advice for anybody that doesn't do it on a regular basis. But the stand that you take depends upon where you sit. So if I'm working with the buyer and it's a FERPA transaction, then I'm going to do something for benefit of the buyer. The seller, same thing with the seller. So that's an important aspect. It's like if you're working with the buyer, how much down payment do you suggest they put down? You don't say, well, let's get
Like $1,
90%.
right?
Yeah, right. And I think that's an important aspect. So it is what it is. I mean, they get mad at the attorneys, they get mad at the realtors because they weren't aware of this. Like, we're going to hold their money, and that's not the case. So
Yeah, I think your mindset is perfect where, you didn't exactly say this, but this was the sense I was getting, that when asked about it, you say, look, I'm not the expert, but I know who I can lean on. I know where I can get the information. Let me re-educate myself. Let's get you the information you need. And Dad, you and I talked about that earlier. When you're approached with this, you say, it's a great point. It's a good question. Let's get an answer. Let me get in touch with the attorney, and we'll do a conference call and we'll figure that out together. Let's go to the expert. And my grandfather used to say that, right, Dad?
I mean, I was raised on that, and he broke it down for me. You're complimenting your customer, so they get all puffed up, and boy, I'm smart. I came up with a great question, And he said, people will see through you in a heartbeat if you BS them. I mean, you're dealing with CEOs and wealthy people down here. You got to be honest and straight. And it's okay not to know everything. And God knows, I mean, most lawyers don't know this. I mean, this is highly specialized. I mean, Christian, you have an aunt who works for the IRS in Washington, DC. She works on one code section. And when I have a problem, I call her on her cell phone and she puts me in touch with the FERPTA guy. And honest to goodness, it sounds like he's in a closet and he's 108 and you can hear the pages rustling and you get something, but it's really complex. You just want to be able to show you've done it before. You can't lie. I mean, it really will hurt you. You're putting yourself in harm's way. Special agents are scary people. They actually carry guns. I mean, these are the real deal, these people. Just like Department of Justice, criminal
No
prosecutors.
kidding. Mike, you had a point you wanted to make.
Yeah, actually, and Don, correct me if I'm wrong, but when someone's asking you to explain FERPTA and the ramifications and all that, one out would be that you're not really allowed to give legal advice. I mean, really, it's you're kind of getting real close to that line there. And so rather than feel funny about referring them to someone else for that advice, I mean, you might use that kind of as a crutch that you're not really allowed to give legal advice.
You're not. But my point is just say, great question, Joe. I've done it a million times before. It's in the contract. FARBAR treats it differently. I mean, for a heads up. But you got to know that it's 15%. You got to know there's ways around it, and you have a guy.
So
And how you
Andrea
hold
makes
title is
another
very
good,
personal.
That's what Jerry says. He's from Jersey. I got a guy.
I got a guy. He's from
That's
Newark.
So Andrea makes another really good point. From my understanding, the IRS will not let you apply for the ITIN until you need it. Why would the buyer need an ITIN until he sells the property? It's one of those things that the seller, the form that's created requires the buyer to also have their information on it. So the buyer's name, buyer's address, and buyer's taxpayer identification number. And so in that scenario, the buyer did need it. The IRS actually has a publication. I'm sharing, not the publication, but some guidance that they have. So Treasury decision.
515, I think it is.
Yep. So requires all transferees, who are buyers and sellers of U.S. real property interests, to provide their TIN. So it is an obligation. It is something that a buyer could do themselves. But most of our clients will hire someone to do it and just kind of make it really easy.
And bottom line, Christian, they're going to have to file a tax return anyways, even after the withholding, which most people seem to forget. So if you're near the tail end of the year, let's say you're in November and the IRS has 90 days to apply for a withholding certificate, you're probably better off waiting until February when the new forms are available and just filing a regular return and get a refund.
Yeah, and that's something that's changing. It's changed a lot after COVID when the IRS got backed up a lot. But I hope that was helpful. I don't know if I didn't want to get too much into the weeds, but make it very simple that there are rules here. We're following them. We will help you and guide you through it. But on a Saturday night, I don't want you to get held up. I want you to make your offer.
Make it assignable.
Make sure it's assignable. Make your offer. Follow up with us as soon as possible. And a lot of times we do take calls on the weekends, maybe not midnight on a Saturday when you're putting your offer together.
I'll be unconscious. But
Yeah, just you could text me and try, but it happens. So we're
it's
trying
not
to get
6
there
months
before
a
you.
day either. It's 50% of the time it's in use.
Yeah, so if there are questions like that, buyers worried about it, reach out to us. And in the meantime, get that offer out. Thank you to everybody that joined, and